is Haji Abbas Mawanda.
The rest?
Thank you, Mr. Chairman. My name is Emmanuel. Thank you, Mr. Chairman. My name is Emmanuel Baluti from Baluti and Company Advocates. I represent Connections, Tours and Travel Limited. Connections, Tours and Travel Limited.
You are representing those companies?
It's one company.
It's one company?
Yes, Mr. Chairman.
What's your name?
Emmanuel Baluti from Baluti and Company Advocates.
Where are your clients?
Mr. Chairman, my clients are not here. I have been designated to make a formal written submission in response to a letter that they received from Messrs. Ibale Nyakato and Company Advocates.
Good morning, Chairman. My name is Mahmoud Barwani from Alliance Holdings Limited.
Good morning, Chair and Committee. Alex, standing in for Mr. Joseph Chassi. We represent Alliance Holdings Limited.
Representing?
Alliance Holdings Limited.
Thank you, Chairman. Abel Wenom, Legal Alliance.
Other members, please find the microphone near you. Introduce yourselves.
Good morning, Chairman. I'm Humza Dan, representing Shumok Group of Companies.
Mr. Chairman, I am Haji Jintu Sekulima.
Juko Lukanga Amwega Abbas Mawanda.
Good morning to you all. I'm Ibrahim Custodian Bilibawa, Member of Parliament representing Makinde East constituency. I'm the Vice Chairperson Cosase and the Chairperson in the subcommittee which is investigating the anomalies in Custodian Board. You're most welcome. Members, we are going to start with the issue of Plot 9, the Winton. Thereafter, we shall move on to Plot 1, Wilson. We shall end with Temangalo. Our witnesses, some of you have invited you several times, you have not been appearing. This committee is not a torture chamber as some of you think, but it's a committee which want to right the wrongs which was done during the repossession, which has led the government lose a lot of money. And this is in your own interest to appear and you explain how you did repossess the property, rather than being there when you are not certain whether you own the property or the government owns the property. But I would like to thank you for registering your attendance, at least for today. And I wish that we help the committee by giving them the truth and the truth so that we can reach to a positive conclusion to both of us. Before we start, I would like to invite you to all what is in front of you is for us, so that you can take as we keep on chatting in a friendly way. With that, I would like to call on Mr. Mukesh to submit, then Baruch submits, and the custodian board, then members comes in, and I conclude. Thank you.
Mr. Chairman, I think I request you to allow the lawyer to produce the letter of communication which we have been doing with the party.
Mr. Chairman, we have written several letters and our correspondences and addressed it to you in person, to the committee at large, on the matter pertaining Plot 9. As you can check around through our correspondences, our clients got the certificate of repossession recently from you. They have never picked it from the custodian board at all material times. But a letter offering certificate of repossession was picked by connections in 1982 without our client's knowledge. And they went ahead in 1996.
No, 1992?
Without our client's knowledge. Because at all material time he was waiting for the certificate of repossession.
No.
Now, in 1996, when our client had deposited the owner's copy of the title to Mr. Mukesh as a representative here, connections went ahead and registered itself on the white page in lands without the owner's copy. How they got there, we didn't know. They started collecting rent. Purportedly, that they have acquired the interest from the 3/4 of the property, because the property was subdivided into 4 plots. They left one in the names of my clients, and the 3 they purported to have acquired them from the previous owners. As you can see in our letter, they communicate to our client around 2010 and threatened him with criminal action if he does not surrender the title for Plot 9. There was a letter written by Custodian saying that if he doesn't do it immediately, he will be prosecuted, and they will institute both criminal and civil proceedings.
Can you submit before this committee those letters to which they did threaten Mr. Mukesh for criminal?
I thought I'd made an attachment on those ones, but I can't give them. It is here. Reference itself.
proceed.
Our client honored the request and handed over the title to Connections Uganda Limited. But ever since he has been persistently demanding how did they acquire the interest and from those properties and to register themselves. And when you look at our letter, he was demanding Connections to furnish him with either the agreement or any form of how they acquired the interest in the property. And when you see the last correspondence from Baruti, they calculatively dodged the question. They did not tell us how their client acquired the property. They just responded to us how they got a letter of repossession. So it was almost a surprise.
Council, if I may ask, was the property a tenancy in common, or it was one person's property?
No, it was not a one person property. It was a tenancy in common.
Can you tell me those were part of that?
Chairman,
Procedure takes precedence.
Mr. Chairman, I'm failing to understand the case. Is Mr. Mkeshi laying a claim on his share or no other shares? Because we also need to, when the way it's proceeding, it's like it says they have an interest, which is not an issue as of now, but council seems to be submitting on other shares. I don't know whether they also lay a claim on that, because if we don't sort it out from the word go, we may not know where exactly.
Let him first tell us those who own the property, all of them. Then I'll rule on your procedure question.
I can make a clarification on that. When we came to know that Connections would direct our client to purport to have bought shares, interest in that property, and yet on the repossession certificate, it was issued for 4 parties.
Who and who?
It was East African Aluminium Works Limited, Avenue Grocers Limited,
Avenue
Grocers Limited, Laxiben Waji Shangan, and Shatalal Hagan Meta. Now, when our client realized that all this time he was being hoodwinked and these people fraudulently entered into the title and took over the possession, he has never had communication from the people, the 3 of them, that they had relinquished their interest to a third party.
Have they ever complained that as the owners of these other units that
since they left in 1972, they have never made any appearance. The presumption is he still holds the interest because they issued 1 certificate of repossession to 4 people. So, and he had never picked it. So the presumption was, when they make appearance, they will ask him, where is our property?
Council, you said members 1,
and the tent is 1.
Members who have known the former owners of the property, and the property was a tenancy in common. Now the issue in are they claiming for the 4 the all interests, even the 3 interests of the interest of others too? Even then, we purport that all of them never came back because when you look at the certificate of repossession, it's still under custodian board. That means all of them, none of them came back.
None of them came back. And
so, in a situation, council, in a situation that none of the expropriated property, the original owners of expropriated property did come back, what is the effect of the property?
The one is East African Aluminium.
No, the question is very, wait. You say all of them, they didn't come back.
The 3.
The 4.
No, the 4.
Because there would be effect of that. Because if the 4 came back, why do Armenian fail to repossess the property? Because according to the evidence we have, the original certificate of repossession, it was never picked.
True.
It is with Custodian board. You purported to have said, if I had quoted you well, that connection picked the certificate. And the letter of repossession.
Precisely.
He picked the letter of repossession. That means the property, because you never completed the process. So what did you use to transfer your interest?
Actually, our interests were never transferred. What happened, there was change of names. You see, for us, we hold one property there and contested. That is escrow. The 3, how they got transferred, it is election, which knows how it did it.
Address the procedure point for your ruling, because you see, Council, if you alluded yourself to a letter of repossession,
Sure.
and a certificate of repossession, and if the letter of repossession had the effect of conferring this property to the repossessor, that would mean that the minister dealt with the property. And once the minister deals with the property
goes to
now the property, it becomes a different matter from what you are raising.
precisely.
Chairman, the point I'm making, he alludes to the letter of repossession, and he say maybe the letter had an effect of conferring the rights to the repossessors.
Precisely.
And once you say that we did this letter, this got registered, Mr. Chairman, what I was seeking you to rule on as to whether we have the jurisdiction now to entertain a matter where they say there was repossession and it is with other people. If they have a claim for other than their share on the 3 shares, I think the best forum, it would be them to sue those people for taking their interest other than, because for us we're dealing with expropriated property.
Precisely.
What
happens like this?
And yourself, you are admitting to a letter which you claim repossessed. That's why I wanted the chairman's guidance on how we proceed.
Mr. Chairman, to add to the matter, I think this brings out a huge legal question to be answered.
Precisely.
And that legal question may not fall into our jurisdiction.
Precisely.
Why? There is the repossession certificate talks of East African Aluminium Works Limited and others. Therefore, the property was jointly owned. In your presentation, you seem to claim that connections or connections got onto the title without your knowledge or the knowledge of the 3 other parties. Which 3 other parties are not here to complain.
Precisely.
And precisely you're here to complain on their behalf. Just a second. By the fact that you dispute the entry of connections on the title, it means they are there illegally in your opinion. And that's not a matter that this committee can adjudicate over, both in law and in fact.
Precisely.
What we can adjudicate over is the issue of repossession. And one, as a result of one complaining, either as the former owner that my property was illegally repossessed, or the custodian board saying that the property was illegally repossessed, whether by all the 4 or by you as a person. But coming to this committee to decide on whose quota it was might be asking us for tall order, and that may be probably
Council, before you come in, Before me, I have a letter written to, is it Bumba and Company Advocates, Ambassador House?
Yes, yes.
Original land title, if I can read for members to, I'm going to roll honorable on your point of procedure, but we need to first get to know some facts here. When the letter reads original land title, are we together? Original land title, you can read for us that later because you have it.
The one of Bumba.
Yes. And who is Bumba?
He was a council representing ESCON, Uganda Limited.
ESCON?
ESCON.
He was a council.
He was a council by then, representing our client.
Then Deo Nkuzingoma. On the same letter, I'm saying it was attention Deo Nkuzingoma.
Attention to Byaruhanga. W. Byaruhanga. It says here, attention to W. Byaruhanga.
I'm reading this one.
Okay, this one, Bumba said that original land title.
No, who is Bumba?
Bumba. Well, Bumba was a lawyer representing my client.
Then Deo Nzingoma
was representing Byaruhanga.
Connection.
Yeah.
Uh-huh.
We hereby enclose you original copy of the title.
Proceed.
Of that title, plot 9 Dwayton Road for the division of 2/4 to 1/3 of the portion. Please arrange send back
of our
portion. Please arrange send back the same on completion of the division process. Kindly acknowledge the receipt of the title.
Signed by who?
Signed by Mukesh Chopra.
My question is, why would you send a title to someone whom you don't know to do subdivision? Because you are contesting, you are contesting the acquisition of those properties by that company connection, and here you are sending a title to those people to do subdivision. Why do you send a copy to a person whom you think, you believe in your wisdom that he doesn't own those that unit?
Our client never appreciated. He feared to be prosecuted of criminal proceedings from a letter from Kasile Byaruhanga.
He feared of what?
They threatened him from criminal proceedings, and he did not address himself at that material time how these people had registered their interest. And I want to tell this committee, I'm alive to the fact and cognizant that this committee cannot resolve issues of fraud, issues of ownership. I'm very cognizant to that fact. But you see, the nature of this claim and how we appeared here, it came to us as if you had a broader investigation, not for purposes of making adjudication, but to keep yourself aware of the transaction which happened and to help Custodian board if they had any claim to see how we can
solve that claim. Wait, you talked of a repossession which you got from us. No, from us here. From the repossession certificate. Can you show me that repossession certificate?
It's here.
You agree that this is the one you got from us?
See, Chairman, last time also we said that we had only a photocopy.
You had a photocopy. Mr. Vizibu, can you show us the original photocopy of it? Answer to your client, come. Come here. This is this certificate I'm the one, this is my signature, and this is your my signature. Of the photocopy. This is the original photocopy. This is the one I have. Is this the same with yours? You see, members, the reason why, and is a council, why I had to critically look into these documents. I have a letter before me to the Vice Chairperson, Cosase, and when you read the content of this letter, it was indicating that their intention to show connections. And among the documents they attached in this document, there is a certificate of repossession, which has my signature. When I got it there, I sent my signature. But on theirs, they added the following words. They added the following words on a government document which they want to present before court in a situation when they are saying that they got the certificate, this certificate from the committee, the photocopy from the committee. But they added that some notes on the same certificate. It was the intention to link the judges into a different thing. If they have a good intention, why would you add words, other notes on the certificate? Because it would say, yes, I would, because it will mean that because there is my signature on the certificate, that this is a true document. This is not a true certificate. Please, give us an answer.
You see, can I answer you?
Let me first answer.
Give us an answer.
You see, what happened like this? Courts don't allow secondary evidence. This one, he gave me as a copy and made a footnote for my own purpose. So, if we are talking of when we go to court, we don't use a photocopy where somebody has put a note to judge a document. They will require for us to bring the original certificate of repossession. So, if we made an error by putting our footnotes for purposes of my benefit, it shouldn't be used against us as if it's going to incriminate you that you are author of this document.
Legal counsel.
Can I address, Mr. Chairman?
We can address.
Let us agree that while we are not having a photocopy in 97, as we are saying,
Ms. Amkesh,
the copies of this certificate.
Ms. Amkesh, I want to appreciate your submission on the same, but we are on the issue of adding a notes to the original certificate. Moreover, you are taking it before, because the copy I have, that is intention to show that you are using the same when you are going to show that. But on that certificate, which I have, is totally different from what you have.
Mr. Chairman, as I am saying, there are several people in the company. There is legal assistance. When they receive a copy, they have made their own notes. This is not signed by company people or anybody. This is a personal internal notes.
Legal counsel.
For the advice of the chair counsel. Because this case is going to the council for further counseling and advice to the company.
Legal counsel.
And one more thing, Mr. Chairman, I want to draw your attention is that we are not saying we didn't have the copy of this certificate before. We didn't have the original. As I had already told you earlier.
You didn't have the original?
Yes.
But you had the
We may have, I don't know. These are photocopies. So I'm saying we have not claimed that we are saying this certificate for the first time.
Mr. Amkesh,
yes,
if you are saying that you received that certificate on the
copy.
That copy on the first incident, would you, when your council was submitting, you said they picked without your knowledge, and you are saying it's not the first time to see it. Which is which?
What I'm trying to say is, this is just a copy circulated to the legal section, and the notes being made by one of the legal assistants from the company or as an internal memo. It has nothing to do with...
Before I invite Custodian Board, Legal Counsel.
Honorable Chairman, it is clear that the certificate that was issued by the Custodian Board did not have the notes that are on this certificate. Now, that means this document has been altered, and that is criminal. It is criminal. If you have to make notes, you put a document, you attach, you don't alter a government document. You don't alter a government document because it amounts to making a false document under section 345B of the Penal Code Act of Uganda, which says that any person makes a false document who alters a document without authority in such a manner that if the alteration had been authorized, it would have altered the effect of this document. So, while we appreciate that probably it is for the internal use, avoid altering government documents. Make your notes elsewhere, but not on government documents.
Here is the question of government document, Mr. Counsel. When this is a photocopy?
Of what?
Photocopy of the original.
Now, let me ask...
Mr. Chairman, let me first finish. Is this a matter of joke? I'm saying that this title is our property with four owners has given us the original certificate of title, which was been obtained under...
Mr. Mkesh, put what you are saying on the record.
Yes, it is okay.
Just put on your microphone. Then, Mr. Mkesh, before you proceed.
Yes, sir. What I'm saying is, we are not...
Can't waste our time coming here to joke.
No, so what I am asking is, where is the title deed?
I want you, Mr. Mkesh, I want you, when you are addressing this committee, to have a bit of respect or decorum to this committee. You are reading papers, you are talking to us. Really, you should also have some bit of respect. Yes, you might be big, you might be what, but please respect this committee. I don't want to revoke some of the rules of procedure.
Mr. Chairman, we are out of order. I'm just referring you about a photocopy of this certificate. And let Mr. Counsel handle.
Mr. Visible.
Thank you, Honorable Chair and members. Chair, as instructed by this honorable committee, Honorable Chair, we submitted that this is a property that was expropriated, and one Patsotam Narandas Raja applied for repossession, and he paid all the requisite funds, the £50, and the property in question was the East African Aluminium Works Limited. Honorable Chair, the letter authorizing repossession was issued in 1992, and thereafter a certificate of repossession was prepared, which has never been collected to date. Despite some reminders, nobody bothered to come. Honorable Chair, and the effect of that, that would amount to non-return after being authorized to repossess within the specified time of 120 days to physically operate and reside in Uganda as per the law at that time.
So what is the effect of non-return to the property in question?
Non-return, the minister may decide on how to deal with that property where the owners never return to operate physically.
So then proceed.
Honorable Chair, with me I have the divestiture worksheet of 1997 where consent transfer was applied, and the members decided or resolved that the transfer only affects a quota share which belonged to MS East African Aluminium Company Limited to be transferred to MS ISCON Bakat Dananta, according to the notes here. And this was presided over by Honorable Sam Male, Mwerende, and Augustine Okello in 1997.
Is that what you have to submit? Yes.
Counsel for Mr. Mukesh, you've presented your case very well, and you've heard from the Custodian Board, and in effect you have no rebuttal on any of the facts. Is that you duly applied, from what I hear, under East African Aluminium, it duly applied and paid, and even consent to transfer to ISCON was given by the divestiture committee.
To
transfer a quota
share.
A quota share. Thank you very much. So, Counsel for Connectious, in the principle of fair hearing, can you tell us why you're also here?
Thank you, Mr. Chairman. Mr. Chairman, before I make my formal submission, as I earlier prepared, please allow me to highlight some of the factual errors that have been brought out by Counsel for ISCON, because if they remain on your record, then they will be misleading. Mr. Chairman, you alluded to a letter from Nkuzingoma from Ruvumba and Company Advocates. Mr. Chairman, I request to respond first to the matters raised by Counsel for ISCON to highlight major factual errors which, if they were allowed to remain on your record, would negatively impact my client's title. And once I've done that, I'll also present my client's position. Mr. Chairman, you referred to a letter from Ruvumba and Company, and Counsel for ISCON told this committee that Deo Nkuzingoma was acting for William Biaruhanga. Those were his words. Mr. Chairman, any senior lawyer in this room would know that Ruvumba and Company Advocates is actually a law firm attributed to Deo Nkuzingoma himself. So Ruvumba and Company Advocates, or Ruvumba and Nkuzingoma, are one and the same. Ruvumba and Mkuzingoma are one and the same. It's also a fact that they said a very senior advocate, former president of the Law Society, was counsel for Mr. Mukesh and Schumacher Group of Companies. So this committee will make its finding, Mr. Chairman. Mr. Chairman, I also wish to highlight that it is not true that Connections picked a letter of repossession in 1992. As will be seen in our submission, our position is that this property was repossessed by its former owners, and the three of those former owners sold their 1/4 each interest to Connections Tours and Travel. Regarding the property, council mentioned that the property was subdivided into 4 plots. Now that in itself is an error. The property is not subdivided, because once you say that the property was subdivided into 4 plots, that could mean that you have 4 land titles in respect of this property. The position, as the committee obviously might know, is that there is one title that is co-owned. Initially was co-owned by 4 owners, but now is co-owned by 2 owners. Mr. Chairman, I also want to highlight that Council in his introduction mentioned that he's representing ISKCON and Shumuk. It should be emphasized that he cannot expand his instructions to represent 3 other co-owners, former co-owners of this property, except if he wants to also go on the record to say that he is now representing those other 3. Council mentioned that ISKCON never transferred, that there was never a transfer from the former owner, which I believe is East African, to ISKCON, and according to him, it was merely a change of name. We dispute that. We know that ISKCON is a separate entity, incorporated, and the reason I'm very sure about that, Mr. Chairman, is that as recent as the year 2018, ISKCON and Connections jointly asked me to undertake certain rectifications on this particular title. So I have more information probably than Council could have, and I have records here where ISKCON wrote to me recognizing that Connection.
Can you submit those records before? Is it part of what you have submitted?
No, it wasn't. But
can you submit that?
It's on my client's file, so I will present the originals for inspection and leave a copy.
Please.
Mr. Chairman, specifically the letter being alluded to is a letter dated 24th August 2018, addressed to Kasirye Biaruhang and Company Advocates.
Yes, you can read it verbatim so that members can know.
In that letter, it's signed by Mukesh Shukla, trustee of the local committee for International Society for Krishna Consciousness, and he says, plot 9 the Winton Road, subdivision of a quarter division apportionment. The above matter refers, we wish to thank you for starting on the process of obtaining for us our title in brackets quarter portion through your appointed counsel Emmanuel Baluti, who is myself, who has already finished the change of name through those still missing work for the new title deed. The change of name here, Mr. Chairman, that is being referred to was initially the title had been registered on the part of ISKCON. The title had been registered in the name of ISKCON Uganda Limited, and they changed their name around the year 2018, only recently, to International Society for Krishna Consciousness. After changing that name, they sought to register that change on the title. So both co-owners appointed a mutual advocate to handle the process, and that was myself. So Mr. Mukesh has always been aware that Connections is his co-owner. He goes on to say, obviously he was referring to the process that I was undertaking. So Mr. Chairman, I thought that this was important, that this letter goes on the record.
Yes, you read it through so that it can...
However, when I contacted him for final transaction, he told me it required town planner to revisit the property first before recommending the separation of our titles. It is for this reason that we request you to instruct him once again to follow up with the next steps of establishing the new title for Connections Tours and Travel, while we could be returned the original title for separation. So these two co-owners actually know themselves.
But Mr. Chairman, I raised the procedure point. Maybe for the
let's
record.
say for the record, I wanted the Council for Connection also to submit, and indeed it was my ruling has also helped to shed more light on what the Council for ISCON had represented. But members, when you look at what they have presented and you critically look at the title and the letter before us, intention to sue, to me, I feel that as a committee, for us, we have got, because our terms of reference is the repossession. Those criminal and issues, we don't handle them. Indeed, as the Council for ISCON has mentioned, I therefore,
and Council, both Council, Mr. Mukesh and Council Iba, like you've heard, because if the matter comes to us, it would culminate to impeachment of the entire repossession. Now that causes another question. But what I see before you is one party is not comfortable with the other. And now that's not a matter procedurally we have jurisdiction to adjudicate over. So I would like to, through the chairman, to implore that any other legal means may suffice, but the chairman must rule on that. But what I see here, ours is contestation of repossession, and contestation of repossession would mean the collapse of all interests, including yours. That is where we don't want to divulge into.
Much obliged.
Now that the question which rules of procedure, the way how we are trying to divert, it was going to the area where this committee cannot handle. I therefore rule that on the matter of the repossession, the committee will make its report on the same, because we have had Custodian Board, we have the facts before us submitted by both parties. I therefore rule that they can proceed on what they feel that is not they are not contented with them. They can concede, they can continue with their court process, but as a committee we stay this matter. We shall make our report on the same based on the documents we have, but on other issues they can proceed with the court matter. With that, I adjourn this, not even adjourn, because adjourn that means I will have to interface it again on the same, but I think the committee would wish to drop this matter as Mr. Mukesh and this connection and Connections Tours and Travel Limited with ESCON, they can proceed to court to settle that matter which is beyond our jurisdiction. With that, I wish you well when you are going back to your workplace. Next.
Thank you.
That is plot 1, Wilson. Custodian board, where is Mr. Bizibu? Where is the executive secretary? Our witness, do you have any written submission you would wish to submit before